Two very different people are watching this. One of you is an attorney. You have a case file open, a client who is getting worse instead of better, and an adjuster who has gone quiet. The other one of you is the person in that file. You are in pain, you are behind on something, and somebody has told you to be patient. I am going to talk to both of you because the thing that is happening to you is the same thing, and almost nobody explains it out loud. Here it is. Your case is not being read, it is being scored. I have been doing this work for 25 years, and I built injury experts because of one failure I could not stop seeing. A patient comes in, the patient does not get better, the file closes, and that person disappears into disability and Medicaid, which is to say, all of us pay for the rest of their life in installments forever. Or somebody misses a concussion, not out of malice. Nobody looked in the window where it was still findable. And that patient spends 30 years being told their headaches are stress. Both are preventable. Neither is prevented by working harder inside the same silos. So we stopped working in silos. Let us talk about the machine, and let me correct something I have said myself, because getting this right matters. The most widely used claims valuation software in this country is called Colossus. Built in Australia in the late 1980s, brought to the United States by Continuum in 1992, acquired by Computer Sciences Corporation in 1996. And after CSC merged with a Hewlett-Packard division in 2017, it became the property of DXC Technology, which licenses it today. I have previously connected Colossus to Berkshire Hathaway and to Charlie Munger. That attribution is wrong, and I am retracting it here. What is not wrong is Munger's sentence, and it is the whole ballgame. Show me the incentive, and I will show you the outcome. Colossus is not the only one. Xactimate, Decision Point, MBRS, CCPR. There are hundreds. Colossus is simply the biggest and the first to go national. And here is the part that should stop you. The software is not corrupt. The software does exactly what it is told. Everything that goes wrong at the keyboard. Severity is scored off the terminology in your medical record. Not your suffering, not your MRI, the words. So if the treating physician writes a note in ordinary English instead of the vocabulary the model recognizes, your score drops and your injury did not change at all. The record simply failed to encode it. Then there is prognosis. Somebody has to enter a prediction about your future. There is a field for it. And when a claims handler reads past 30 pages of documented deficit and enters prognosis, excellent in the files we review, that one word moves an offer by 20 to 40%. Then there is repricing. A patient has radiating leg pain down to the foot. We perform a selective nerve root block, targeted, image-guided diagnostic. It comes back recharacterized as a trigger point. Same day, same needle, different code, different money. And then the inputs nobody wants to discuss on the record. Zip code, redlining code, geography and demography entered into evaluation of your spine. Adjusters and their reviewers are making coding judgments outside the training anybody gave them. That is not an insult. It is a structural problem, and the fix is not to shout at them. It is to hand them a record so specific that the judgment is already made for them. You should be skeptical of a doctor telling you the industry is scoring you down. So do not believe me, believe their own sales literature. The Consumer Federation of America, in a report called Lowball, documented the vendor's own pitch, that the program would, quote, immediately reduce the size of bodily injury claims by up to 20%. That is not an allegation from a plaintiff's lawyer. That is the feature list. The same report tracked Allstate's payout per premium dollar in auto injury cases, falling from roughly 63 cents to roughly 47 cents in a single decade. Show me the incentive, and I will show you the outcome. Now, the piece that is hardest to say out loud. When an economist projects what an injured person would have earned across a lifetime, that projection starts from a baseline table. In a survey of forensic economists, 43.6% said they would use both race and gender data in projecting lost wages. A further 48.1% would use gender-specific data. The mechanism is not subtle. Historically, women and people of color earned less. Feed that history into a projection, and it comes back out as a prediction about one specific person's future. The disparity is not observed, it is imported. If you think I am overstating it, do not argue with me. Argue with a legislature. California passed SB 41 in 2019. It took effect January 1st, 2020. It is now California Civil Code Section 3361. And the operative sentence is this: estimations, measures, or calculations of past, present, or future damages for lost earnings or impaired earning capacity resulting from personal injury or wrongful death shall not be reduced based on race, ethnicity, or gender. A legislature does not ban a practice that is not happening. Counselor, we looked for a Missouri equivalent and an Illinois equivalent. We did not find one. So if your client's damages include lost earning capacity, there is a question worth asking out loud in your next call. What tables is this projection built on? Missouri has a statute on this, Revised Statutes of Missouri, sections 375.1000 through 375.1018. It defines improper claims practices: misrepresenting facts, failing to investigate, refusing to settle without a reasonable basis, unreasonable delay. And it is written to reach claimants and insureds, not only the person who bought the policy. The injured third party is inside that language. Let me be precise, because this room includes lawyers. That act is enforced through the Missouri Department of Commerce and Insurance. What it supports inside your specific case is your call, counselor, not mine. My job is narrower, and it is the one I can guarantee. I will hand you a record where the failure to investigate is documented, dated, and obvious to anybody reading it later. Here is something patients almost never know, and it is brutal. In Missouri, Section 303.390, if you were driving uninsured, you are barred from recovering non-economic damages. Pain, suffering, the life you had, gone, even when the crash was not your fault. There are narrow exceptions, including a drunk driver, and the statute is being fought over in Missouri courts, but it is on the books today. Work injuries. In Missouri, under Section 287.140, your employer picks your doctor. Cross the river into Illinois and you choose 2 providers, with referrals covered. Same injury, same week, 2 miles apart. 2 entirely different medical realities, fault. Missouri is a pure comparative fault state. You can be 99% at fault and still recover, reduced accordingly. Illinois is a 51% bar. At 51%, you recover nothing at all, which is why intake matters more than anything that follows it. How you were hurt and where decides what your medical record has to prove. That is the machine, and that is the map. What I have not told you yet is the part that decides most cases that the evidence itself has a shelf life, and most of it is gone before anybody thinks to look for it. That is part 2. If you are an attorney with a case open right now, do not wait for it.